So we talked about this article when it first came out on October 14th in 2020, and it wasn't the case for the time, right? Clarence Thomas was looking at trying to figure out what the proper way to go about Section 230 was, and he wasn't necessarily against the idea of curtailing or reforming, however you want to put it, Section 230. It's just the case before the Supreme Court was not one that warranted such an overhaul. Like as we can see here, what the original case was about. Thomas said his fellow justices were right to pass on the case, which centered on whether Malwarebytes, an internet security company, could be held liable for what Enigma Software said was a wrongful designation of its product as malware. But he said it should welcome the chance to scale back Section 230 from the bench through a different case. So we covered this before, but just to go over it once again. Extending 230 immunity beyond the natural reading of the text can have serious consequences, Thomas wrote, adding that when the right case comes to court, it would behoove the justices to consider a narrower reading of the law. And that's what we have today. There was a whole bunch of cases in front of the Supreme Court, whether they would take it up or not. And the cases that was before the Supreme Court today involved President Trump's Twitter feed and whether or not Facebook, Twitter, Google itself are tastemakers in the public square. We all know this is the case. I don't think anybody's going to be arguing against that. Actually, I should take that back because there are some lolbertarians out there right now. We'll actually take a look at one, and it's hysterical to say the least. Like, here's one of these big brain fucking takes. Like, Josh Hawley's pointing out a part of the opinion that was written by Clarence Thomas, and we'll get into it in a minute, but the Libertarian Party of Texas, with their big brain takes, Clarence Thomas, it's okay for the government to seize the means of production and force companies to host speech they don't want to. These motherfuckers are out here complaining that people might be saying some objectionable things when it comes to telephone communications, and somehow having them host that speech on their airwaves, that would be this somehow Republicans devolving into socialism. Or you know what, if somebody's using the electricity or the natural gas that's coming into their house in order to power their fucking meth lab out back, that's somehow socialism to let people act freely on a platform without having to fear repercussions based on nebulous terms of service. Oh yeah, but my private company though. Fuck off. God, libertarians piss me off. That's why whenever you got to do that, I'm sure most of you are probably familiar with the political compass, right? There's the right, there's the left, and then there's the up-down spectrum. And then up top is the authoritarian side of it. And then at the bottom is supposed to be more liberty-minded individuals, and it just gets defaulted to using the libertarian tag. And as you can see, the modern-day Libertarian Party are fucking worthless and goddamn retarded, because it kind of all started their whole downfall. They really should have had a stronger presence in the 2016 election, right? But who did they nominate? Who was the guy who was running? The same one, because they can't attract anybody to their fucking party that has any sense in their goddamn heads. They had Gary Johnson out there, right? He had the Aleppo moment. Oh, what's Aleppo? Well, Aleppo is a city in Syria. And they were going through some tough times in the lead up to the election, and as any natural interviewer would ask of a political candidate, what would you do with Aleppo? Gary Johnson, what's Aleppo? And then to follow it up, not but this within the next couple of days, or maybe it was even the next day, he was out there sticking his tongue out and acting like a complete and utter fucking jackass, okay? But you might think that, hey, that was 2016, they excised their demons. No, but the next lady that they nominated for their fucking Sterling party, somebody who might have had even a little bit of a chance, because Jill Stein of the Green Party got kicked off of so many fucking presidential ballots out there for the 2020 election. Thank you, Democrats. They were going to be the major third party that was going to be out there. But instead, Joe Jorgensen, at the height, in the summertime, of all of the political unrest, all of the riots that were going on, what was her big brain fucking take on everything? It's not enough. This is the Libertarian Party after all. Tweets out, it's not enough to be racist, you have to be anti-racist. In a different verbiage, we could probably still find the tweets. Actually, just so I'm not proven wrong, we will go ahead and do that. Yes, there it is, July 10th. It's not enough to be passively not racist. Remember, she is the Libertarian Party, the party that is not supposed to tell you to do anything, that is supposed to be anti-interventionalist. We must be actively anti-racist. Could you literally miss the point any farther? Black Lives Matter means standing in solidarity with the mourning black communities as we fight together to end qualified immunity, police brutality, sentencing disparity, and the war on drugs, because that's all the Libertarian Party cares about anymore. MAPOT, not support any organization by that name. And that's why they registered in the 0.5 percentage points in many, many states out there, because it's a fucking joke party now. I don't know how we got on that point, nor do I really care. All I know is every time that I bash a Libertarian Party, I have very good reason, because they suck. It's just the party of pot, man. Just leave me alone. I just want to sit at home and coom all day. Fuck off. Let's get back to the good stuff. Supreme Court Justice Clarence Thomas appeared to signal that big tech firms could be regulated after Facebook and Twitter suspended President Donald Trump earlier this year. Thank God. Thomas, considered a conservative on the High Court, you don't say, made the point during a 12-page submission as the Supreme Court issued an order that rejected a lawsuit over Trump's blocking of certain Twitter users from commenting on his posts before his account was taken down. It was not an illegitimate claim. Remember, this was early in his presidency when he was blocking those very annoying reply guys that were out there, which I don't know what they're doing right now. I'm pretty sure most of them are on suicide watch because they have nothing left to do with their life. But then it was decided that President Trump's Twitter feed would be considered a part of the public square. It's the place where he would most congregate with his supporters, his voters, everyone from around the world, just about amounting, 90 million people by the time that he was banned. But it was ruled that he was not allowed to block anybody because that would be silencing their First Amendment right. But that wasn't extended to anybody else. And if you take a look at the YouTube page for the White House right now, there's a very, very obvious reason why YouTube is getting rid of the dislike numbers. I haven't seen it come across any of my videos, and if there's any videos out there that you have seen, I try to stay away from content that infuriates me in the evening once I'm done creating my videos, so I haven't really come across any of it yet, but I know it's out there, and that's the key reason behind it. Some media channels are thinking that it's because of big business like Disney or whatever other woke corporation is out there creating really terrible content, that they are also just lobbying in YouTube's ear to get rid of the dislike count because they get constantly ratioed all the time on their woke shit. I'm not going to discount that. That could definitely be a part of it, but it's got to be Joe Biden in the White House because those everywhere they get fucking bombed. Washington Post, if they're redistributing any of the content that comes out of C-SPAN or straight from the White House itself, every single time that a live stream or some kind of messaging comes out of the White House, it gets destroyed. But that's totally fine, okay? Trump on his, what was it, real Donald Trump, right? He wasn't allowed to ban anybody. He wasn't allowed to block anybody. He wasn't allowed to mute anybody because that was a part of the public square. But leaving a comment or disliking a video, that's totally fine. Just turn your head and don't mind the old man on the throne. Anyways, back to this. Today's digital platforms provide avenues for historically unprecedented amounts of speech, including speech by government actors. Also unprecedented, however, is control of so much speech in the hands of a few private parties, Thomas wrote Monday. We will soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructure, such as digital platforms. I'm sure these were the exact same conversations that were going on after Thomas Edison, or whoever actually did invent the telephone, Alexander Graham Bell. Thomas Edison created the light bulb. I'm retarded. Sorry about that. It eventually got to the point where, these were needing to be federally regulated because you can't just start putting things into people's house and then, all of a sudden, you're having a conversation we don't like, fucking pull the plug. No, you can't really do that. And the fact that there are state-sponsored accounts on Twitter, that leads us all to believe, and the same designations are on Facebook as well. They're becoming integral to everyday life. Like it or not, I don't like using Twitter. I haven't used Facebook since end of high school. I like Gab, I like Parler, verified as a real human being on Parler for whatever that means. But if they all disappeared tomorrow, and for Parler again, I really wouldn't care that much. Okay? But still, they are essential to communication on a wide scale. It provides dissenting opinion, especially when you have publishers out there like CNN, like the New York Times, actively turning off comment feeds on their own outlets, and then they're just allowed to say whatever they want without fear of any repercussion. So this needs to be addressed. Thomas also noted there are arguments suggesting digital platforms such as Twitter and Facebook are sufficiently akin to common carriers or places of accommodation to be regulated in this manner. Hence the reason why I made the telephone analogy. I think it's apt and it's been used several times, but it needed clarification, of course. Thomas made reference to respective owners of Facebook and Google by name: Zuckerberg, Larry Page, and Sergey Brin. Although both companies are public, one person controls Facebook, Mark Zuckerberg. Yes, he, at the end of the day, has the axe. It doesn't matter if there are other board members there. He can still make the final call. And to control Google, Larry Page and Sergey Brin, he wrote. Thomas agreed that Trump's Twitter account did resemble a constitutionally protected public forum in certain aspects. He noted that it seems rather odd to say that something is a government forum when a private company has unrestricted authority to do away with it, possibly referring to Twitter's ban against Trump following the January 6th incident. What else could he possibly be referencing? Any control Mr. Trump exercised over the account greatly paled in comparison to Trump's authority dictated in his terms of service to remove the account at any time or no reason, he added. Twitter exercised its authority to do exactly that. And that's the problem, right? If they actually had verifiable rules and regulation, like Steven Crowder recently went through a Twitter ban. He's back again for however long, who knows. But when he was told that his account was suspended, he was provided with an explanation, except the explanation spot was blank. So how are you supposed to know why you get kicked off a platform? How are you supposed to know how you're supposed to play between the rules if you aren't informed of the rules? It's like when most channels are getting hit with COVID disinformation or elections. What in the video was wrong? I don't know. The whole video. What? No, I've made different comparisons. I've said many different things. I probably cracked a couple of jokes. What in there? What specifically can't I say on YouTube that Rumble and Odyssey, other places out there, which I like just as much? Probably a lot more because obvious reasons they allow me to say a bunch of other things. No, instead when you get struck and when you're allowed to appeal, which tends to just go right into the fucking ether anyways, it just gets crumpled up and thrown away. I think I've won, 4 of 3 dozen different appeals that have been filed against me. So, but never, ever, ever. The only thing that comes up is, our policies have changed in line with our 2020 election provisions. Oh, okay, what do you mean by that? They've changed. How have they changed? They have. Thanks. So like Clarence Thomas is saying, they're just vague. And perhaps the government has to step in. Always cognizant of the fact that government is very rarely ever the answer, right? The 9 most pernicious words that anybody can string together, according to Ronald Reagan: I'm from the government and I'm here to help. But when it comes to this situation here, could you imagine if today's corporations, if Coca-Cola, if Delta, if Major League Baseball, if they went out there and they were in control of water and wastewater, or if they were in control of electricity right now, how many Republicans would have access to drinking water in their homes? Oh, they'd just be keeping you safe, obviously, if somebody doesn't have power or somebody doesn't have water, right? They'd be able to find a way to justify it. Or maybe they just wouldn't even bother telling you at all because I'm a private company. Anyways, Thomas then said that modern technology isn't easily addressed by existing laws and regulations, but he warned that the Supreme Court may soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructures such as digital platforms. The Second Circuit Court feared that then President Trump cut off speech by using the feature that Twitter made available to him, Thomas said. But if the aim is to ensure that the speech is not smothered, then the more glaring concerns must perforce be the dominant digital platforms themselves. As Twitter made clear, the right to cut off speech lies most powerfully in the hands of private digital platforms. The extent to which that power matters for the purpose of the First Amendment and the extent to which that power could lawfully be modified raised interesting and important questions. Thomas noted that the big tech firms had a vast amount of power over the flow of information, even books. He said it doesn't matter that Amazon, Facebook, Twitter and others are not the only way in which to distribute speech as long as their power to do so is unequaled. Exactly. You can always create your own company, right? If you don't like the rules and regulations, you can just go ahead and do it yourself. Until Amazon buys you out. Until Facebook and Twitter act together in order to deplatform you. Not saying that's ever happened before in early January. So clearly, the Supreme Court is ramping up. Right now, it looks like Clarence Thomas is probably the de facto Chief Justice. It really doesn't matter who it is. All it takes is 4 Supreme Court justices to take up one single case. And when it comes to this issue, Thomas, Alito, you'd have to think Gorsuch is probably on board. So you just have to convince one of the other 2 cucks that Trump appointed, and Kavanaugh or Barrett, to maybe hop on board, or who knows, whoever Joe Biden gets to replace Breyer in the near future would be able to hop on board, because who knows, maybe there are a couple of fair-minded liberals still out there. So this is great to see. It doesn't matter how you slice it. It looks like Thomas has a much more clear indication as to the type of case and the type of problems that need addressing when it comes to Section 230 and it comes to all of these big tech industries. Clearly, he knows which ones have the monopoly on the industry. We could name them off, but it takes somebody with actual significant power to name them off, to rattle them off, and to show that they understand the power that they wield and how it's not fairly applied. Plain and simple. So that's why you hope that maybe, if I can bring up Steven Crowder's name again, one of those lawsuits, maybe the one against Facebook, if there's any pending litigation against Twitter, something like that, if that reaches the Supreme Court, maybe that would be justification to go back on Section 230, take a look and update it from 1996 when it was first put on the books. Seems a little outdated if it was anything else, right? Christ, it'll be 25 years old this year. What? That's like 15 years too old for Bill Clinton. Anyways, guys, I thank you all very much for the gift of your time. I've been Don Consuelo. I want you to follow your gut and get after it. Take care, everyone.